When you were back before us last week, Mr. Taylor, both you and the minister made reference to a Court of Appeal case in Alberta that you said had broadened the definition of transmission. That's not actually what the case you referred to just now did. I'm quite familiar with this case because it involved an Edmonton murder trial. And just so that my colleagues in the room understand what happened, in that case, a 14-year-old girl was murdered. At the time of her death, her photograph and her name were widely reported. When charges were eventually laid against the man accused of killing her, the court imposed a publication ban on the child's name. And then the Attorney General of Alberta charged the CBC with criminal contempt because the CBC did not go back through its archives and remove her name from previously published stories. And the CBC, represented by Reynolds Mirth of Edmonton, fought a case to the Alberta Court of Appeal. There was an injunction sought by the Crown at the Supreme Court, which turned them down. And the Court of Appeal clearly said that it was unreasonable to expect media organizations to go back through their archives and ex post facto censor them. That what has been part of the historical record was part of the historical record. That's what the case did. So what you're telling us now is not that you're trying to narrow the definition of transmission, but that you put that phrase otherwise made available in to respond because you don't like the way the Alberta Court of Appeal decided this case, which was a landmark case in protecting press freedom. Is that would be a more correct understanding, right, of what otherwise made available is doing in the act?
Right. So to the extent that we weren't clear on that, I appreciate the opportunity to I appreciate your comments. I appreciate the opportunity to respond to your comments. Yes, I mean the decision at issue at the court of both at the trial level and the Court of Appeal went through considerable effort to trace back the meaning of the terms in the provision, publication ban provision, what they capture and what they don't capture. So when the court provided their understanding of the meaning publish, which is to make public, to disseminate broadly, they talked about transmission, and you're right, they made clear that within their interpretation of those provisions, it did not capture the going back in time and removing. As I said, that decision led to calls for law reform, not just by the federal government, but by all jurisdictions through the Uniform Law Conference of Canada to address that gap. And that's what the bill attempts to do, is to address the potential for continued harm to victims whose name continues to exist on websites or archives, and that cannot be removed currently, or is not captured by the scope of the publication.
So it's just that last week when you were here, you said to me and to Senator Boisvenu and to Senator Batters that the problem was the transmission was too broad and could include private emails. That's not true. I mean, transmission has been clearly defined. It doesn't include private correspondence.
Perhaps there were two different issues that we were discussing. I think the concern...
I don't think so.
The concern around transmission, as I understand it, vis-a-vis victims, is that transmission as a concept would capture the kind of sharing of information that you've just described, and that is concerning.
Is there any jurisprudence that says that transmission includes private personal correspondence?
Well, I think, as I said last week, there is limited jurisprudence, and what we do know, so from that decision, the concept of transmit includes broad dissemination,
yes,
causing anything to be conveyed. We know in the context of other areas of law, transmission in the computer data provisions. Transmission does include one-to-one transmission through email.
All right, so I have time for one more question. Is there not a concern, and I have to tell you, I met with the lawyers who litigated this case earlier this week so that I could sound like I knew all the facts and I remembered them. The concern they raised to me is that if you put in the phrase otherwise made available, that it would capture every public library, every newspaper archive, every archived Google story, that it would capture, a provincial archive, that you can't, once someone has legally been named, it is not a reasonable expectation, and both the lower court and the Court of Appeal in Alberta agreed that it is not a reasonable expectation to expect people to go back and edit history. Any public library could potentially be charged with, I don't know if it would be a criminal contempt or a different charge, because they left a hard copy of a newspaper on a shelving unit.
Yeah, I think those are fair concerns. I think they are fair concerns, legitimate concerns. I think the minister said last week he was open to considering these issues. As I've said earlier, we're trying to support the minister in working through some solutions to some of the challenges that have been identified.
Thank you very much.
Senatrice Clement.